I'm David Parker, and on the historical committee of the Nashville Bar Association. And one of the things we do is our lawyers in town reach age 70. We take their biography by video, and so therefore others can hear what we've done and things like that. Now, the reason the lawyers do that, because if we didn't do it, nobody else would. We have a memorial service committee, and the reason we memorialize lawyers who die, if we didn't do it, nobody would. But anyway, now we have with us today is Steve North. And Steve is one of the more interesting personalities in this town. And he comes from a long line. His dad was the minister of the largest Church of Christ congregation in the world out at Madison. And so, the Norths have been everywhere. And his wife was the very politically motivated, and she was the assessor of property for 15 years before she retired, then a long time on the Metro Council. But Steve, we're glad you're here today, and I want to welcome you and to hear about your past. Would you tell me something about where you were born and when you came to Nashville?
I was born in Abilene, Texas. My mother and father were teenage college students, and I interrupted my mother's college education by coming along, and so they were both students at Abilene Christian College. After that, after my dad graduated from Abilene Christian, we came back to Nashville for a while, and my early elementary school was at David Lipscomb kindergarten and first and second grade, and then we moved to Baton Rouge, Louisiana, and my dad got before that we moved to Urbana, Illinois. My dad got his master's at the University of Illinois, and then we came back to Nashville for a while. He taught at Lipscomb for a while, and we went to Baton Rouge, Louisiana, and my third through fifth grade was in Baton Rouge, Louisiana. My dad was getting his doctorate at LSU, and then we moved back to Nashville and moved to Madison when I was in, I guess, the 7th or 8th grade. I graduated from Madison High School. I went to Abilene Christian for a year, went to Lipscomb for 2 years, was a senior in absentia at Vanderbilt Law School, graduated from Vanderbilt Law School in '65.
Mm-hmm. And I remember several things about you during your time at Lipscomb. I remember one day I was down on the second floor, and you were up on the third floor, and we heard this hollering up it was the worst guitar playing and singing, and I got up there, and you were up there with Hugh Trigg, and you were leaning up against the wall, just beating that guitar to death. But anyway, well, what influenced you to go to law school?
I was having an awful lot of fun at college, and my dad was a professor there at Lipscomb when I was there, and he came by. I was sitting in the student center there at Lipscomb, and Dad came by, and he threw this sheaf of paper down on the table, and he said, "Son, you're wasting my money, you're wasting my time, you're goofing off, you're not studying, and you've got a choice. This is an application to Vanderbilt Law School. You either fill it out or get a job." So I filled it out. And at that time, Vanderbilt had a senior in absentia program where after your junior year of college, if your grades are a certain level and if you have met certain requirements, then you could do your senior year of college as your first year of law school, and then after your first year of law school, you would get your degree. I wasn't really worried. I didn't think there was any way that I could get in Vanderbilt Law School, and there was no one quite as shocked as I was when I got an acceptance letter. I was very excited about that. So that's how I ended up going to law school. It wasn't because there were no lawyers in my family, so far as I know. I had never been inside a law office. didn't really have any idea of what law was about or law school was about.
When you went, did you start up at Kirkland Hall, or they did go in the new building after your first year?
We were, if I remember correctly, we were the first class to start in the new building.
Okay.
It was 62.
Yeah.
And but we were in the new building, but I think they had just moved out of Kirkland Hall.
And all right. And okay, you started out with Howell and Fisher, is that correct?
Yes.
When you graduated from after graduation, how did you come to go to work for Howell and Fisher?
The summer of I guess after my second year, I was looking for a clerk position. Mm-hmm. I worked my way through law school as a preacher in Spring Hill, Tennessee, and lived there and commuted to law school. And I was looking for a job. And my dad, again, was friends with Frank Clement, who was governor at the time. So he called Governor Clement and said, my son needs a job. And Governor Clement said, well, have him go see Doug Fisher. Doug Fisher had been general counsel for Frank Clement, had run several of his campaigns, and had been his law partner. Yeah. It was Clement, Sanford, and Fisher, Val Sanford, Doug Fisher, Frank Clement. And so I went to see Doug Fisher, and he hired me. And then when I graduated from law school, he hired me again in, I guess, August of '65. Mm-hmm. In January of '66, he said, I want to make you a partner of Howell and Fisher. That time it was Doug Fisher and Morton Howell. And I said, oh man, I've got it made. I'm really doing great. That's wonderful. So I became a partner. And then I did happen to ask him, what does that mean? He said, well, that means that you have to pay your share of the overhead, and you have to make whatever you make after you pay the overhead. And I realized that was slave labor. That was not a partnership. But at least my name was on the letterhead as a partner.
You know, see, Doug knew what he was doing when he made you a partner.
Doug was a great mentor. I think he was, in that era, he was the best trial lawyer in the state of Tennessee. And I learned an awful lot from him.
He was always well prepared.
In those days, this was before the rules of civil procedure. He had a notebook that he called his loophole notebook, and he knew the old code pleading better than anybody. And he loved to go through that loophole notebook and find all of the ways a lawyer could screw up under the old way. And he referred a number of cases to me. And every Saturday morning, we would meet at the office, and he would have me bring all my files and stack them on his desk. And we would go through them one by one. And he would say, well, have you done this? And if I say yes, he said, no, you haven't, because it's not documented. He said, if you don't have it documented in your file, it didn't happen. I learned that. Mm-hmm. And then he said, every Saturday, I want you to come in here and show me that you have done everything that was ripe to be done in that file. Every Saturday. Then we'd break for lunch and we'd go to the Gerst house to the round table. And really the round table was where most of the lawyers that actually tried lawsuits always ate lunch. 'Cause for some reason, at that time, lawyers always worked half a day on Saturdays.
That's exactly right.
And they'd go to the Gerst house, sit around the round table, and young lawyers would learn more about the practice of law sitting around that round table. And we didn't have a board of professional responsibility. The board of professional responsibility for the bar was the round table at the Gerst house. And their enforcement was, if there was any lawyer, particularly any trial lawyer, who had engaged in any questionable sharp practice. That's what they called it.
Sharp practice.
Some would call it dishonesty, or some would call it taking advantage. Anyone who had done anything that cast any kind of aspersions on the practice of law, they would tell about it at the round table. And the discipline was that lawyer would never get an agreed continuance or an agreed anything from then on. And as young lawyers, we were much more afraid of the judgment of the round table than we were of any bar association or any board of professional responsibility, because those older lawyers sit around just listening to them talk. You learned that the law was an honorable profession, that we fought hard, we vigorously represented our clients, but we treated each other with respect and dignity, and that we were members of an honorable profession. I don't know whether that answered your question or not. I probably
No,
answered
that answer, then that leads into, for those of us who started when we did, and it was so totally different. And what, like I said, you were always careful. If someone called you and they needed a continuance on something, you tried to grant it, because I tell you what, if you didn't, the word got out of the way you were. And buddy, you had a hard time operating in there. Well, what about how do you think the practice of law has changed from when we started in 1965 or 66 as to what it is today?
Well, there are a lot of differences. And I don't want to sound like some old fart that is talking about the good old days, because there were some bad things about it, and there have been some improvements. But I think the biggest change, and I don't think it's for the better, is really two things, both of which were started with the best of intentions. One is the almighty billable hour, and the second is the rules of civil procedure. The almighty billable hour has created these huge multi-state law firms. If I remember correctly, when I started practicing law, Bass, Berry & Sims was the largest law firm in Nashville, and I believe they had 10 lawyers.
That's right.
We were a fairly large law firm, and we had 4 lawyers. Now, if you don't have 100 lawyers, I went to an arbitration in New York recently. This law firm was, I think, 28th through 47th floor of this building in Manhattan. And I asked the lawyer that I was dealing with, I said, how many lawyers do you have in your law firm? And he said, well, here in New York, 1,600. Now, worldwide, several thousand. How do they manage to do that? The almighty billable hour and abusing the discovery process. We have changed trial work into an abuse of the discovery process. When the rules first came in, we thought, oh man, this is going to do away with ambush. It's going to do away with surprise. It's going to make litigation so much quicker and cheaper and fairer, and it did just the opposite. Jack Norman told me one time, Jack Norman Sr., I was a very young lawyer, and he was an experienced older lawyer. He said, Steve, if you ever see me with a file thicker than 1 inch, it's a multi-million-dollar lawsuit. Now, if you've got a $500 lawsuit or a $1,000 lawsuit, you've got a stack of boxes of paper 6 feet high. You have answered hundreds of stock interrogatories, and you have generated $100,000 worth of lawyer time, and God knows how many trees in the rainforest have been used up by all of that paper. Remember when email came in, they were going to do away, we were going to have the paperless office?
Yep.
I've got a case right now before the Court of Appeals. It's the 4th or 5th time the case has been up. Just the record for this case is over 16,000 pages of paper. All came about because we thought we were simplifying things.
Yep.
We thought we were going to make it fairer. And did you think we've done away with ambush? Now, the places to ambush lawyers in trial cases, they ought not to call them trial cases, because cases don't go to trial anymore. They're either mediated or they're arbitrated or they get dismissed on summary judgment, or somebody misses a deadline that some judge has artificially set, or someone fails to answer 100 interrogatories on time and request for. I was representing a plaintiff in a death case against General Motors, and I was associated with some out-of-state lawyers. In answer to one request for production of documents, UPS came to my office and literally filled up almost to the ceiling my entire reception room with 100 boxes of documents. I opened one of them and someone had just emptied a trash can into the box, sealed it up, and sent it as a response to request for production of documents. When we first started practicing, before the rules of civil procedure,
Yes.
back in the days of trial by ambush,
Yes.
if it took more than 90 days from the time the case was filed to the time it was tried and over with, it was because somebody was intentionally dragging their feet because the lawyers had determined that this case really would benefit from some time. Mm-hmm. Now, we have scheduling orders, we have all of these deadlines, and if you can get a case ready in 3 years, and a file that will go to the ceiling, that's at least 3 or 4 banker boxes. You've seen these lawyers going into the courthouse to try a simple case, and they've got a hand truck, and they've hired somebody to bring in 4 or 5 huge banker boxes full of files on a very simple case that would have been, that probably been going on for 5 years, that would have been tried in 90 days before we improved the system and made it fairer and made it cheaper. That's one of my soapboxes.
Well, do you find yourself, with the coming of what you were talking about, just mountains of paperwork and discovery and all, and scheduling orders, that you spend as much time every day making sure that you're in line with the scheduling order as you do really getting to the merits of the case?
Absolutely. And I'll tell you how that started, in my opinion. Back in the 70s, they started having these national judicial colleges. And there was one in Reno. And the state would pay for every new judge to go to the judicial college in Reno. And they had this theory that lawyers were the enemy. that lawyers will fool around and load down your docket if you don't stay right on them all the time. You've got to set up scheduling orders and scheduling conferences, and you've got to check on the lawyers to be sure they're doing their job just all the time and stay on them all the time. Before that, the judicial attitude was, these lawyers are grown men and women. They know what they're doing. They know more about their case than we as judges do. And when the case is ready for trial, and if they need any help getting someone to file an answer or respond to discovery or whatever, they'll file a motion. And if they don't, it's because these lawyers are honorable people. They're learned people. They know their case better than we do. And when the case is ripe, they'll set it for trial. And the judge's job at that time was, when a dispute is brought before you, you decide it. But you let lawyers be lawyers, and you let the lawyers handle the case. The attitude gradually changed. And I have to admit, I was a part of the cause of that, and I regret it. I confess my sins. The attitude is that the judge, for some reason, has got a responsibility to intervene in every single case and control everything the lawyers do. Well, the result of that is the lawyers get lazy, and they don't do anything unless a judge orders them to do it. And instead of preparing their own case, getting ready for trial, setting it for trial, doing it when it's ripe, they wait for a judge to order them to do it, and then they try to figure out some way to get out of doing what the judge has ordered them to do. As a result of that, you've got cases that take years and years and years and years to get ready, and tremendous expense, to the point that litigation is to the point that then, in order to avoid all of that expense, you have these fast track mediation. One of the things I've learned is that the more a judge tries to intervene, and the more the judge or the system tries to set up controls over lawyers, the more lawyers learn how to manipulate whatever rule you make. It's in the lawyer's best interest, financial and otherwise, to get a case prepared, try it, get it over with, and go to the next case. But rather than following their own best interest, they wait for a judge to order them to do it, and then they try to figure out a way to keep from doing what the judge has ordered them to do, when the judge ought to stay out of it. That's one of the big changes, and it took place because it all goes back to these, what I still call the new rules.
The new rules. You remember the little booklet when they came out with the new rules of civil procedure? It was in this tiny little booklet, and you just had it. And do you remember how the judges gave you a year? You could do it both ways.
Yeah. And
because those of us that came up with pleas and abatement and demurs and all like that, you just, one thing we were taught in law school: don't trust anybody. And you get over there with that thing, and you wonder which way you're going to do it. So the judge would just say, "Okay, just do it both ways for a year."
Can I tell you a funny story about the rules of civil procedure?
Yeah.
I was a young lawyer. At Vanderbilt, we had studied the federal rules and the Tennessee rules. The professor that taught Tennessee practice was Justice Harbison. Yep. He wasn't a justice then. He was a lawyer, but he was a good lawyer. And then he was chair of the committee that drafted the Tennessee Rules of Civil Procedure. Well, I was a young lawyer, and I had filed a motion with regard to one of the rules. I cited all of the federal interpretations. I was absolutely sure I was right because The Tennessee law was rule was exactly the same as the federal rule. And I went over to argue it before Judge Miles, First Circuit Court. Bill Harbison got up and said, "Now, Judge, when I wrote that rule, here's what I meant." And I realized I had no chance. It was all over. It didn't make a difference what the federal rule said. But anyway.
You know, how did you left Howell and Fisher and ran for judge?
I did.
Why did you decide to leave? And Howell and Fisher is one of the finest firms you could work with. Why did you leave Howell and Fisher and decide to run for judge?
Well, I was, at that time, we were representing Aetna, and I was assigned a case from Aetna that involved 2 death cases at the Tullahoma Arnold Engineering plant that involved 2 men that were suffocated in an argon gas furnace because a gas flow meter had a gasket fail, leaked it into the furnace. The men died. I was assigned that case. There were 4 or 5 really good plaintiffs' lawyers. J.D. Lee was on the other side. Tom Wiseman's law firm was on the other side. And it was a 2-week trial. And I was over there by myself with this manufacturing firm from Milwaukee, Wisconsin. J.D. Lee had given an interview with the local paper saying that he was going to set the record for death cases in Tennessee with these cases. Tried one day, I legitimately billed 23 hours in that day, and the other hour I did not get any sleep. So we tried that case, and I won it. I was driving back from Winchester after that case, and I was feeling pretty good that I had won the case. And I remembered there was an article in the newspaper that said that the legislature had set up a system of compensation for trial judges that would provide for cost of living increases so that the new salary for a circuit judge was $32,000 a year, up from $17,000. And I got thinking that surely there is a better way, honorable way to make a living as a lawyer besides the kind of pressure. And in this case, I had missed Christmas with my kids. I had missed New Year's with my kids. I had been on the road back and forth to Winchester and Chattanooga and Milwaukee, and I was totally exhausted. And I said, you know, where am I going to be in 20 years? I'll be trying these kinds of cases if I'm lucky, and I won't know my children. And my wife will probably be with her second husband, enjoying all the money I'm making. So the next Friday, there was a motion docket in front of Judge Sam Feltz. Judge Feltz and I never got along. I thought he mistreated young lawyers. And I thought he was irascible and lazy. Just my opinion. His court officer came up to me and had an endorsement petition. Said, "Want you to sign this endorsement petition, the election's coming up." And I said, "No, I won't do it. The way he treats me, I'm not going to endorse him." And he looked me in the eye and he said, "You'll be sorry." And I said, "What?" I might as well run against the SOB. And I did. Excuse my language. And I was 32 years old, never been involved in politics, didn't know anything about politics. But I figured he couldn't treat me any worse than he was treating me now, and he certainly was not going to treat me well if I didn't endorse him. So I ran against him and I beat him. And I did it by I figured that if I could shake hands with 3,000 people a day for 6 weeks, that most people didn't care who their circuit judge was, but they might vote for somebody that asked them. And so I spent all day, every day for 6 weeks, shaking hands anywhere I could find a crowd of people. I rode the elevators downtown at the First American Building, all the office buildings. At lunchtime, I would get on the elevator and I would shake hands with everybody coming off. We'd go up every floor. Anybody get on, I would shake their hand, ask them to vote for me, give them a card. Then on the way down, everybody that got on, I would shake a hand. I rode the city bus routes. I would get on a bus downtown and ride it to the end of the line and then ride it back. Shake hands with everybody that got on, ask them to vote for me, introduce myself, spend some time talking to them, and then come back. I'd drive around at night and try to find a factory that was letting out. The shift was over, shift change. I'd get there and I'd shake hands with everybody that came out, ask them to vote for me. And I got elected. And so that's how I left Howell and Fisher.
Well, I guess that was a change. What kind of cases well, no, let me precede this. You know how sometimes people at church can be when you become a lawyer, you become a judge and stuff like that. What did you find? You had to apply the law, but what did some of the people at church expect you to do?
Well, back up just a little bit. I told my grandfather, who was a conservative undertaker in Lawrence County, I told him I was going to law school, and his response was, "Son, can't you do something honest?" There was, in the area of marriage and divorce, there were a lot of people that thought that as a judge I ought to follow what I believe the Bible says rather than what the law was. And I felt like that'd be violating my oath of office, and it was not my job to enforce my religious beliefs on somebody else. So there was some pressure there. I represented. Remember one time the elders at the church wanted to suggest that I take some office, and I said, I'm not sure you want me to be an officer of this congregation. Understand, I represent right now the largest gay nightclub in the Southeast. And there are people in the congregation that would be upset about that. And I did represent them. So they decided that perhaps it'd be better for me to give my contribution from the back row and not be on the front line.
And well, your dad was a preacher at the largest Church of Christ congregation in the world. How did that influence you?
Well, before I went to law school, I was talking with my dad, and I had serious ideas of being a preacher. And he sat me down and said, "Now look, remember the Apostle Paul. He was a tent maker, and he could make a living doing something besides preaching. He said, if you feel like you've got to preach, then that's fine. But you get an education and learn how to do something else. So you're not dependent on the whims of the brethren in order to feed your family." And so I went to law school. The one time that one of my classmates at Vanderbilt was Frank Drewota, later Chief Justice of the Supreme Court. Well, he was appointed to the Chancery bench shortly before I went on the bench. He was a very prominent Nashville preacher's son. Yeah. For some reason, the district attorney decided to bring the movie Deep Throat before a chancellor, not a criminal court, shut down the movie Deep Throat, and somehow the district attorney chose the son of a prominent Nashville preacher to have a trial over whether Deep Throat was obscene and whether it should be closed down. At that time, it was playing in downtown Nashville.
Circle 3 Art Theater.
And I remember when the movie Deep Throat, Frank decided to appoint a blue ribbon special advisory jury that chancellors can do. Mm-hmm. And so he had professors from Vanderbilt and social workers and all sorts of prominent people that he put on the jury. And I remember one of the things he had to do was show the movie to the jury. And he did it in open court. And I remember when Deep Throat played the Chancery Court of Nashville, and the room was packed with lawyers to watch the movie. The lawyers didn't want anyone to see them in line downtown to get into Deep Throat, but they wanted to see the movie. They were sitting in the windows and had completely packed the room. Well, Deep Throat was a satire of pornographic movies, and it had some really funny lines in it. And when one of those lines would come on, the lawyers in the room would just laugh and goof off, and tears would come to their eyes from laughing. The jury decided that Deep Throat couldn't violate community standards because we've got half the bar association think it's great. They're laughing their heads off over the movie, and so they decided it was not obscene. Put Frank in a very difficult position. He was the son of a very conservative, prominent Nashville preacher. And so he ruled it obscene anyway. A little later on, I was on the bench. I had just taken the bench, and I was a circuit judge. And there were 2 massage parlors in downtown Nashville, the Magic Fingers and the Magic Touch. And the DA had tried several different ways to shut them down, and they kept losing the case. And so the DA decided to bring to a prominent Nashville preacher's son who had just been elected, very young, just been elected, the case of the Magic Touch and Magic Fingers massage parlors. And obviously, my father had very strong opinions about that. From the time I got that case until it was over, he was not allowed to call my house. He would call my house. I would not answer the phone. Joanne would answer the phone. And she would say, "Now, Paul," we called him Paul, "Now, Paul, you can't talk to Steve till this case is over." "Well, I just want to see how he's doing." She said, "He's doing fine. You can't talk to him." "Well, just tell him to remember his training and to do what's right." She said, "I'm not going to tell him anything, and you're not going to tell him anything, and he will not talk to you until after the case is over." And the case went on for several weeks, and it was front page headlines and an editorial in both the Banner and the Tennessean almost daily about the case. And it was kind of funny too. And I appointed an advisory jury, and it split 6-6. 6 said shut it down, 6 said leave it open. I finally shut it down because it was a traffic hazard, because the masseuses would advertise the massage parlors by walking up and down the sidewalk wearing trench coats and nothing under them. And they would flash motorists as they went by. And there were several, excuse the pun, rear-end collisions as a result of lawyers looking at the girls flashing on the side of the road and smashing. So I shut it down as a traffic hazard, not because it was obscene or was a house of ill repute. So yeah, there were times.
There was somebody named Tootsie that testified more.
Tootsie Bess. She owned Tootsie's Orchid Lounge. She complained that the girls that worked at the massage parlor would parade up and down in front of Tootsie's Orchid Lounge while people were having lunch. And they would wear very short mini skirts and would not, her words, would not wear step-ins. And they would back up and press their buttocks up against the plate glass window while people were trying to have lunch. And she said it was really hurting her lunchtime business. So that was one of the, there were a lot of funny things happened in that case. I'm going to write a book about that case someday.
Well, things were kind of a wild time in Nashville in the early 70s.
Well, yeah, we had Lady Godiva.
Oh, do you remember the time that Heaven Lee
Absolutely
rode down the middle of 4th Avenue at lunchtime?
Absolutely.
And they were all out there, and
I was a witness. It was at lunchtime. I was out at lunch, and I saw the white horse.
I think everybody was there. And I know I had a case with Bill Rutherford. And I was out there, and there was Bill. Bill was out there watching the ride down the street.
Absolutely.
It was Heaven Lee that was riding the horse, and all.
She ended up in my courtroom one time. We were trying a case, and she was friendly with one of the people that were parties. Actually, I think I was a lawyer at the time. I was not a judge at the time. And I was trying the case, and out in the hall, I was representing her friend, but I didn't recognize her. And she came up and introduced herself and said, "Hi, I'm Miss Heaven Lee." I said, "Didn't recognize you with your clothes on."
Oh, me. Well, now I also noticed that you left the bench to run for DA.
I did.
Now, why was that?
Several reasons. One, I think I went on the bench too young. I still wanted to win cases, and even losing cases was better than being the umpire. I thought I could still play the game, and I was tired of calling balls and strikes. I wanted to care about the people that were involved, and I wanted to win. I was too young. I hadn't got all of that out of my system yet. That was a part of it. Part of it was I ended up handling several thousand multiple offender DUI cases, and the more I got into the criminal law, the more I realized that judges get the blame for the criminal justice system, when in fact the district attorney controls what cases go to trial, what cases get settled, controls the system. And if there's a backlog in the criminal justice system, it's the district attorney that controls it. And I was young, and I was idealistic, and I felt like I could change I felt like the world needed to be changed, and that I was the one that could change it. So I decided to run for district attorney. In order to do that, I got an opinion from the I guess the Bar Association, whoever it was that gave those opinions, that under the rules I could not run for district attorney and retain the judicial position. So I resigned and ran for district attorney.
And
found out, by the way, that the world didn't want to be changed, or at least they didn't want me to change it. And so I got beat, and it wasn't close.
Well, how did that loss affect you?
Well, it's never fun to lose.
Because you were not used to losing.
No. It was kind of interesting. Shortly after, I lost that election substantially. My wife won a council member at large race with the most votes any council member at large had ever gotten in history. So I didn't really take it personally, and it was disappointing. And I was deep in debt. I had borrowed money to run television ads and all of that, and I was in debt. I hadn't worked for about 4 or 5 months. So yeah, it was disappointing. On the other hand, I ended up doing what I wanted to do, which was try lawsuits, and I wanted to represent real people. I decided when I lost that election that I was only going to represent clients that had a pulse and that had a body temperature, that had a conscience, and had an immortal soul. That eliminated government, big corporations, insurance companies, and banks. I was not going to represent them. And so I found a law firm that would rent me one room. And I took a desk and chair out of my living room and a couple of easy chairs out of my living room. I bought at a water-damaged office furniture sale. I found a secretarial desk and a credenza. I borrowed a typewriter, and I found a secretary that would work after hours. She would work for a bank, but after hours she would come in and type for me, and I hung out my shingle. Somebody said, well, what would you, close to the, what would you do if you lose? You'll be out of work. And I said, no, I'm a lawyer. I've got a license to practice law. Plus, my name has been on billboards all over town. Everybody in Davidson County knows I'm a lawyer. I'll be all right. And I was.
The one thing I was going to, you became sort of a lone wolf. I mean, you had your, as a sole practitioner and all. And how did you like being a sole practitioner?
It's got its pros and cons. Now, as soon as my middle son graduated from Pepperdine Law School, he sent me a letter applying for a job with a resume, and I told him that I couldn't offer him what the big law firms were making in California, but that what I could do that he couldn't get in the big law firm is he could have an office with a window, and he could be a partner anytime he wanted to carry his share of the overhead. And so he came into practice with me, and has practiced with me for about 25 years.
Well, that's I think when you really learn, I think it's the dream of so many young lawyers. They want to be in this big law firm. They think just because they're in that big law firm, they're going to take care of them. They find out that isn't true. That ain't going to happen.
They're wage slaves. They end up being wage slaves.
And when you're a sole practitioner, you walk in places. I think there's certain types of jobs you take. You and I talked about this when you were there, and as a judge, and you end up with cases and stuff that are very politically incorrect or dangerous. And a lawyer who says he's never been afraid is either a lion or he's a fool, because you're going to be that way, but you got to overcome that and make you handle the stuff that you have.
The thing that I liked about being a sort of a small practitioner plaintiff's lawyer was that there are people come to you that are helpless and hopeless, and you are their only help. You're the only person on their side. You're their only help. You're their only hope, and they put their faith and trust in you. And when you get through with a case like that, and I'm thinking of a case I had where a man ended up after open heart surgery with losing both legs and an arm, and I represented him. in a medical malpractice case. And that was probably 15 years ago. And every Christmas, I get a Christmas card from him with his wife on some cruise or on some tropical island or on some trip that they've taken. That is, even these hardcore insurance defense lawyers that you think have no conscience and have no sense of feeling for anybody, you really ask them, what case do you want to tell your grandchildren about? And they'll say it was that case where I represent a plaintiff that was helpless and hopeless and needed me. These insurance companies don't need them. They don't love them. They don't care about them. I tell my clients, corporations are not real people. You're not in good hands. They're not good neighbors. They're not on your side. They're made of money. And they don't have a conscience. You can't shame them. Even those hard-bitten insurance defense lawyers will tell you the cases they remember and the cases they're really proud of are where they represented some person who had been deeply mistreated and who had no hope except for them. And they were able to get them justice. And those are the cases I remember. And that's why I want to be a plaintiff's lawyer. And unfortunately, plaintiff's lawyers are becoming obsolete. They're being legislated, and rules and advertised out of business. And that's, I think we really lose something.
Well, you remember when we started, you never saw an advertisement, and you couldn't tell somebody you thought they had a lawsuit. You could not do that. I think we either called it champerty or we called it, I can't think of the other name, but you couldn't tell anybody, or you wouldn't, that you thought, hey, I think you got a suit there. Now, if they ask you.
We had a minimum fee schedule that the Bar Association put out, and if you charge less than the minimum fee, it was considered unethical.
Yeah, I remember that.
And we thought, just another one of those things, we said, oh, well, freedom of speech, this will make legal services cheaper, it'll make it more available to more people, and just the opposite. It's done just the opposite.
If you had to do over again, would you go to law school and become a lawyer?
I think so. Yeah, I have, on balance, it's been a good ride, and I've learned stuff. Here's what a trial lawyer does. Trial lawyers are not experts at anything. The talent of a good trial lawyer is to have broad general knowledge and understanding, and in a given case, be able to understand an expert when an expert explains it, some complex area, whatever it is, and then be able to translate, first place, understand it enough so that it makes sense to the lawyer, and then be able to translate that in language that ordinary people who are not trained can understand, and be able to understand in some narrow area of whatever field it is, be able to understand the concept enough to know when the expert is full of it, and be able to know. I mean, I can remember an orthopedic surgeon getting the bones in the leg mixed up, the tibia and the fibula, and he got upset when I looked at the x-ray and I could see, here's where you made your mistake, you know. That's very rewarding, and it gives you this broad, I've had cases involving hydrology, aerodynamics, neurosurgery, orthopedic surgery, circulatory, every system of the body. What other business could I have been in that I could have learned about the heat treatment of metals in an inert gas atmosphere?
Yes, sir.
I've had cases involving the effect of freezing on glass flow pipes for manufacturing the chemicals, dangerous chemicals. Every field that you can imagine. And I don't know of any other occupation where you develop that real estate appraising, construction, mechanics, physics, chemistry, every field of human endeavor, a good trial lawyer will learn something about and will be able to at least have an intelligible conversation about almost any field of endeavor. And that's very rewarding, and that gives a rich life.
And, you know, I before we started, you were talking about talking to people and being able to talk to them. There was a little 6-year-old boy around here, and he was totally mesmerized by what you were telling him. I sat there and watched him, and those eyes got brighter and brighter. He never took his eyes off of you. And, you know, some people could, if they're asked to talk to children or whatever, things like that, you know, they just ball up and they can't. But you held that little boy in the palm of your hand while you were talking about it. One more question. When you were a student at Lipscomb, of course, you and I went to school together and all like that, you know, and you were not nearly as good a student at Lipscomb as you were at Vanderbilt. What caused that?
Well, between the time that I was accepted at Vanderbilt and the time I started, a beautiful and sweet Texas girl agreed to marry me. And we got married in August before I started law school in September. And I got very serious about studying, and I was a preacher's kid from Madison, and I was at Vanderbilt, and to tell you the truth, some of the students at Vanderbilt were sort of elitist, and they sort of looked down on the preacher's kid from East Nashville, who's working his way through law school as a preacher of all things. Yeah. And I was determined that if it didn't kill me, I was going to graduate and I was going to make good grades. And I made the law review, even though I was working full time. And I was determined to do it. And it was time for me to grow up and be a man.
Well, that's exactly right. Well, I want to thank you for submitting yourself to this interview, but things you say will really, you give a very realistic approach to the practice of law, or why we're lawyers, or something like that.
Yeah, can I point out one other thing?
Sure.
When I first started practicing law, there was no such thing as Xerox machines.
Yep.
There was no such thing as computers. or cell phones or fax machines. We didn't even have electronic calculators.
That's right.
And each one of those advances were supposed to have made life easier and more productive, and the justice system worked better. And if you really analyze it, they haven't.
Lawyers began to use those as weapons.
Oh, absolutely, yeah. And you remember when cell phones came in? We said, oh man, this is going to free us up. We're going to be so much more productive. Why, well, we can sit on the beach and do business. Has it made us more productive?
No.
I don't think we're any more productive than we were when lawyers had offices in the Stallman building, and the only way they could answer the phone was to go out in the hall, and there was a common telephone on every floor of the Stallman building, and every lawyer there had to use that phone. And I'm not sure that the cell phone has made us any more productive, and it's created so many problems that we didn't have.
I remember Doug Fisher telling me what the kind of equipment that he and Morton Howell had when they had, the non-electric typewriters and such like that.
Yeah.
And it says we were much better lawyers.
Absolutely.
Then.
I'll tell you one thing. When you did a 10-page brief, it took you a week to do it. And you examined it very, very carefully. And sometimes the secretary would have to type it 3 or 4 times. Now, I saw a lawyer the other day sitting in the courtroom with a little computer about this big and a little printer about this big, and he drafted a 20-page brief in about 10 minutes with cut and paste and with wireless, with the Wi-Fi, internet, and all of that. And some people think that's progress. I don't think it's progress at all. In the first place, he didn't write the brief. He just cut and pasted from previous briefs that somebody else had written in his law firm and printed it out there and signed his name. He didn't have time to read it.
I remember when we started, they took a whole semester at Vanderbilt teaching you how to write and how to learn to use the library. And those of us that learned that, we could do research manually through those books fast. And the thing was, if you learn to do it just with say Westlaw or whatever it is, you don't really learn how to do research. You learn, it's propped up there to you.
But you learn how to cut and paste some out of context quote that supports whatever it is you want to support, and without understanding what the whole case was about.
Well,
among other things. Oh, yeah.
A lawyer has got to be a little bit daring. He has to, do something out there, And I remember I had this case, it was about 12 or 15 years ago. And in one of the briefs I filed, I quoted Uriah the Hittite, the story of Uriah the Hittite. And a lawyer from the firm, they called me over, and he was laughing at me, and he says, "You actually put that in a brief?" And I said, "I did." And what was the first thing the judge brought up the next time we were in front of him? Uriah the Hittite.
We quoted Paradise Lost in a brief on fraud, and won the case. And one of the appellate judges commented on
the thing there. I always thought that being raised...
One Paradise Lost, it was the Divine Comedy.
I always thought being raised as strictly as I was raised, and I was raised very strictly. And my mother just pounded into me the scripture. Well, where did it turn out that it helped me more? New York City. And I was up there in New York, and I had this thing we were negotiating. It took 2 months. And so finally one afternoon, the other man's lead lawyer treated me like a hayseed. And I asked him, I says, "Can you tell me the 12 sons of Jacob?" And he says, "No." "Can you?" I said, "Reuben, Simeon, Levi."
Absolutely, yeah.
And their mothers in order. He said, "Where did you learn that?" I says, "My mother." And it changed the tenor of the whole thing. Anything else you want to comment on?
If I get around to it, I'm going to write a book on, the name of it's going to be, It Seemed Like a Good Idea at the Time. And let me say that it sounds like that I'm just an old fart talking about the good old days and all of that. I love being a lawyer, and I have enjoyed the practice, and I feel like that it is, and I still believe that it is an honorable, learned profession. It's got its faults, it's got its problems, but it's also something that there comes a time when you need to let it go. And I don't want to be one of these old lawyers that can't remember to zip their pants when they come out of the bathroom and still trying uncontested divorce cases. I don't want to.
And that's right, knowing when to quit, because it can't go on forever.
Yeah.
And it just can't. And well, Steve, we want to thank you.
Thank you.
Thank you what you've done for the law profession. Thank you what you've done for the practice of law. Thank you for what you've done to Nashville, because you and your influence goes out a lot further than you probably realize with your dad's influence, your wife and stuff like that. It's just been amazing, and I just want to say thank you again.
My pleasure.
That's it.